a solicitor in England and Wales, and I'm delighted to be hosting this panel session this afternoon about lasting powers of attorney and a wider discussion about the vulnerability of people in older age and reforms that we would like to see about that. So I was going to say welcome from Nottingham, but that made me sound like one of the representatives from the Eurovision Song Contest. But I know we've got a very, very wide group of people tuning in today. So thank you very much for each of you who has joined us this afternoon. So we're going to be talking about events that took place in Scotland. And first and foremost, although we're online, this is a Scottish conference. But all the issues that you'll hear about today are equally important across the four nations. We're going to hear about elder abuse, complacency, ageism, which affect us all in society. I'm an English lawyer working in the Court of Protection and in safeguarding, but we are going to hear about issues which are painfully familiar to me, even though they took place in Scotland. We're going to hear about vulnerability, protection or lack thereof, and state intervention and the degree to which the state should be protecting the older members of society. We're going to hear a bit about powers of attorney, which are known as continuing powers of attorney in Scotland, lasting powers of attorney in England, and enduring powers of attorney in Northern Ireland. But the principles that apply are much the same. And we're going to be looking at how effective we are at protecting people from abuse of those powers of attorney, and also the protection of vulnerable people in later life. So thank you for your reactions. I was going to say make good use of those because it's very encouraging for the panelists to know that people are listening and appreciating what they say. And I'm going to now turn to introducing or allowing them to introduce themselves, our panelists this afternoon. So first of all, can I turn to Laura Johnston and Karen Lee?
Good afternoon. Thanks for having us.
Thank you very much. Now you're going to be telling us a story which is both interesting but awfully tragic as well about your father, Willie Johnston. I'll let you tell that story rather than doing it for you. But thank you for joining us this afternoon and for supporting the event. Also, we're going to be hearing from Tanina. Would you like to do a quick introduction, Tanina?
Yes, of course. So I'm Tanina Ashby. I'm a solicitor in private practice and like Ian, I specialise in court protection matters. So I see quite a lot of LPA abuse, and I'll be talking a little bit about that.
And Colin, would you like to introduce yourself?
Hey there. So I'm Colin Scott. I am a frontline services lead for Hourglass, and I have particular responsibility for our work in Scotland and Northern Ireland, but also I'm involved in our work across the whole of the UK.
Thank you very much. Now, we're going to start by setting the scene, and a very important component of Scottish discussions about safeguarding and protection has been a campaign that is close to Hourglass's heart, which is called Willie's Law. Now, Willie Johnston was Karen and Laura's dad, and they're going to tell us a story now about briefly what happened to your dad and the circumstances that have led you to be here to this afternoon.
Yeah, so our dad was, he got ill very quickly and he ended up in high dependency unit in hospital. He was on quite a lot of medication, which meant that he wasn't himself, he wasn't thinking as clearly as he normally would. And we thought we had done everything right. We thought we had everything in place. We had signed power of attorney documents and We were really focusing on making those last few weeks that he had just, you know, as memorable and as painless as we could. And then unfortunately, he was presented with a document from his business partner and the solicitor for the business that they run, which signed over quite a large amount of money to them. And we couldn't believe that this had happened. We were just in utter shock when we found out. We couldn't believe that it was something that would happen in the first place because you know, you just don't ever think you would be in a situation like that. And then we found out that it was all completely legal and there was nothing that we could do about it, which again was just so utterly shocking to us that someone in the position that our father was in um could be allowed to sign a legal document in a high dependency unit with no medical staff saying yes, he knows what he's signing, yes, he understands this. Um, and then from that point on, it really did change the last few weeks of my dad's life and then the following years for me and Laura.
Yeah, it completely consumed Dad's final weeks because he was aware of what had happened. Due to medications and things, he obviously went in and out of his understanding of what was going on. But once he was aware of what had happened, he was devastated, totally betrayed, even though he said that it wasn't something that he wanted to sign. It had been signed and he was legally held accountable to those documents because we don't have protections in Scotland for vulnerable people like we should.
Thank you very much. And my understanding of the case is that this was something that was initiated by his business partner, rather than something that he wanted to do himself. He was presented with this.
Absolutely.
Yeah, so it had been, sorry. It had been something that his business partner had brought up with him actually two 3 times beforehand between the business partner, my dad, and the solicitor for the firm that they were a part of, for the business that they were a part of. It had been brought up several times, and several times my dad had said, I don't want to sign this. You know, it's not something that I'm interested in. And he had 2 or 3 times over sort of a couple of years prior to him being ill it was brought up, and we only found that out afterwards because it wasn't something that my dad discussed, and it probably wouldn't have been because he would have just thought, well, I've said no, that's it, end of the conversation. But once it had been signed, we found out that it had been brought up a couple of times before, and he had said no.
Yeah.
And that was part of the reason we were just utterly shocked.
Yeah, we only found out what happened because after my dad passed, we decided to launch a complaint and take the solicitor to a tribunal, which was when a lot of the discovery took place and a lot of what had come before we were then aware of. My dad was very proud, living independently, working every day of his life. Right up until the day he went into hospital, he was in the fields. And talking about somebody trying to get him to sign over his insurance money or trying to sign over bits of the farm wasn't something that he talked to us about. It's not, it wouldn't be in his remit. He was a strong individual and felt as if, you know, this situation had been dealt with. He said no, his will was in place, all the other documents were in place that he needed. And before he died, we had signed power of attorney documents, But at the time, we did not know that those had not been launched to the court. So we assumed, because we had never done it before, you sign them, then you have all the protections. And that's not the case. They have to be launched with a court, they have to be registered. And until that happens, the protections aren't there. So the solicitor did not file those documents until after Dad had signed the documents in hospital. So it was a whole big mess that then consumed Dad's final moments, our final time with them, and then has consumed our last sort of 5-6 years now.
And presumably the solicitor who was meant to be filing the power of attorney was the same solicitor who turned up to secure the business transfer.
Yes.
Yeah.
Okay. So all sorts of things were of concern to you there. And what changes have you been specifically calling for, and what reception has it received in Scotland?
So so we've been specifically calling for a change in the law to mimic what England have as the golden rule. So we're looking at capacity specifically. My dad was in a very vulnerable situation when he was in hospital, and he was on a lot of medication. And we found it shocking that the solicitor was the only person that needed to say, yeah, I think he's okay. We found that absolutely shocking, that someone with no medical background whatsoever and could walk in and be like, yeah, I think he knows what he's talking about. Although this solicitor did know my dad, and he knew that my dad had said no to these documents previously, it could have just as easily been a solicitor that had never met my dad before, didn't know if this was normal for him or not. And the fact that no doctor had to be consulted about his ability to understand what he was signing, we just couldn't believe that was the case. We just assumed that there were protections in place, but we later learnt that there are in other parts of the country, but unfortunately not for us in Scotland.
Mm-hmm. During our the tribunal, which was a process on itself, that took 2 years. We weren't allowed to discuss the case or talk to anybody about it. But during the tribunal, on the day, was when we discovered that England had more protection, because that was their main point of defence. We're not in England, so you can't hold us to standards that aren't applicable here. So that in itself was what kind of took us aback, that people, unscrupulous solicitors and people, are actually using this as a way to shield themselves. They know that they can get away with things in Scotland, and they use it as part of their defence. It was mind-boggling for us. We left that tribunal in shock. The solicitor just had to pay a £5,000 fine, and that was okay, even though he was found guilty on all these things. It just made no sense to us, just because we were over the border. If we were in England, it would have been a criminal court that he would have went to. It was a completely different situation.
Okay. And that all sounds very logical and sensible from our perspective. So what negative narratives have you received? Do people suggest that it's too complicated or too expensive or too time consuming to get capacity properly assessed before big changes are made in someone's life when they're vulnerable?
All of the above. We launched a petition, as you know, with the Scottish Government to try and get these changes made. And the government's response has been, there's enough checks and balances in place. We spoke to the Law Society, and they said that they have a charter in place that ensures that their solicitors are doing what they should, because they say they are. The government knows there's failings. There has been a review of the adults with incapacity last year, and part of that was what came out in January was that people acknowledged the power of attorney issues. They acknowledged capacity issues, but yet by the March, the government had decided that those issues weren't to be taken forward. And instead, they're going to set up another committee to discuss it sometime at the end of this year. So it is kind of crazy. These issues are well known. It's well documented. Also, the biggest issue we find is people go, we haven't heard that. There can't be that many people out there with the same issue. But we get loads of people that have contacted us so that they're in the same situation. But they're not talked about because they're going through the proper process. So if they're going through a tribunal, you're not allowed to talk about it. If you're going through a court process, you're not allowed to talk about it. You get caught up in, I mean, we were caught up in a confidentiality clause for a long time. We were not supposed to talk about this or anything related to my dad, for that matter, for a long time. People get caught up in the red tape and the bureaucracy, and it's mind melting for most people. You are re-victimizing people over and over again because they're stuck in this cycle, and then their story doesn't get out. The whole system's designed so that people can't speak out. So when we started talking, we did have a few comments of, these people are just after their dad's money, they're bitter because, you know, he signed over his life insurance. That wasn't the case at all. We are upset that we live in a system where vulnerable people are taken advantage of legally.
Yeah, I mean, we weren't aware that Dad had a life insurance policy at all. So that wasn't something that had concerned us. But we have received comments along the lines of, but that wouldn't happen to me. And that, I think, has been the biggest sort of wall that we have faced, you know, when we are out just speaking to normal, like, people on the street, when we were getting signatures for our petition. We had a lot of people go, oh, but I've got a power of attorney. And we had to explain to them, yeah, but we thought we had power of attorney too. You know, like that, you know, the system isn't as straightforward and it's not as easy to understand. And in a lot of ways, we were quite lucky that we had documented times where Dad had said no to these things previously, and we had nurses that stood up and said, no, you know, he was falling asleep during this conversation. He probably didn't know what he was talking about. We had it documented that Dad's medication could affect his understanding. Um, and we were lucky. We have spoken to a lot of people that have said, we know that our parent, you know, our parent or our loved one wouldn't have wanted to sign this, but we don't have any of that information that you guys had. And we're in a he said, she said situation where, you know, some person has went into the house with a different document and, you know, everything's been signed over and there's nothing anyone can do about it.
Yeah,
Unfortunately.
most people don't find out until after the fact, until after their loved one has passed. We were lucky and obviously very sad to find that my dad found out beforehand. And just by chance, absolute by chance, that we found out beforehand.
Thank you so much. Well, I mean, needless to say, you have the full support of Hourglass for this campaign. There are links to your Scottish Parliament petition, I think, associated with the Hourglass website. So thank you very much for sharing that. Turning to you, Tanina, it is the case, of course, under English powers of attorney that you don't need to have a medical practitioner confirm your capacity to sign one. And yet it's often quite a contentious area whether someone had capacity to sign over control of their affairs to a third party or not. What other areas of concern do you have about our systems that you're familiar with in England and Wales?
Well, I think, you know, just hearing your story is absolutely heartbreaking and typical of sadly what we see in practice. You know, having powers of attorney is a good thing in some respects because it is designed to protect individuals, but there are people that take advantage of the system. It's not a complete safeguard in itself. So yeah, I mean, having anybody, just somebody that's known you for a couple of years, sign off to say that you even understand to sign a power of attorney, I think is bonkers, really. You don't have to have any legal training, any medical training, and I think a lot of the time what we see is individuals who don't actually know that they're doing anything other than witnessing a document. They don't know that they're supposed to be checking capacity and all of that sort of thing. And just hearing from your story as well, I'm sure Ian and any other solicitors on the call will be cringing to think that a professional could be in that position and take advantage and not do the appropriate due diligence. And that's another big failing of the system, is professionals on every level that just aren't doing the due diligence when they're approached with documents and when they're put on notice that somebody is vulnerable. There definitely needs to be more accountability there. Certainly in the recent last few months, I've had cases from the police where we've had attorneys go into, had an attorney go into a bank with a vulnerable person that they acted for, asked for £140,000 to be transferred. The bank said no on the first occasion. The next time they came in a few days later, another 180,000 they wanted, bank said no. And suddenly they produced a loan agreement for 180,000 again just a few days later. And common sense would suggest if it was a loan, a legitimate loan, there would have been a loan agreement on day one. And sadly, the bank transferred the money with no real regard to what was going on there. So I think due diligence from professionals is definitely a big one. Having somebody that's appropriately trained to assess capacity as one of the certificate provider in English law to be able to sign off on the powers of attorney to start with. And I think we're also let down by our, in England and Wales, we have the Office of the Public Guardian that sort of supervise and promote powers of attorney. But there's not any active supervision unless somebody raises concerns. And it's frontline individuals and professionals that should be raising the red flags. And sadly, you know, again, your experience is typical, Laura and Karen, of what we see, which is people saying there isn't a problem because we're not talking about it. And because people who are in this situation, it only gets picked up if someone reports it effectively. So what we're seeing is just the tip of the iceberg in the investigations that go through our Office of the Public Guardian. And even then, there's no real consequences for the perpetrators. There's no automatic order for them to repay assets, even if they're found to have misappropriated them. So we've got a number of areas really, Ian, that I think we need to work on. It's not just one thing that's not working. There's lots of little fixes that we could make to make it a much safer system for vulnerable people and older people.
Thanks, Tanina. Yeah, it occurs to me as a solicitor that one of the main questions that most or many solicitors fail to ask themselves at the outset is, who is my client? Who am I representing to the exclusivity of everyone else? And you often find in perhaps rural communities where families of a number of different members of the family use the same small firm of solicitors, that there is a kind of, there develops an understanding from the part of the solicitors that they're kind of acting for everybody, kind of doing the right thing by the family, and that's an utter nonsense. It's an utter fiction. You're only in your case, Karen and Laura, you know, this solicitor should have taken a step away because the people, the company that he represents, was not the same as your father, which was a completely different identity. And he was finding himself in a situation where those two things, what was in the best interest of the company and what was in the best interest of the individual, may be completely different.
He got away with that because he had two companies, and one was dealing with the firm and one was dealing with my dad's will and power of attorney, but they were still him. They were still the same solicitor, but there was two branches of that. So
yeah, I mean,
yeah.
Well, yeah, it gets very messy. It gets very messy. But yeah, sometimes the fundamental questions are missed out. Sometimes through solicitors trying to be too helpful, and sometimes you've got to draw some very bold and very clear lines about what you can and can't get involved with. Turning to you, Colin, from Hourglass's perspective, this is all going to be very familiar, what you've heard about from Tanina and the daughters. Where do you see this? Where do you see the abuse of powers of attorney coming up in the cases and helpline calls that you receive on a daily basis?
Yeah, so it is, as you say, sadly, all too common for us. I often say about, issues like power of attorney that, I think in principle it probably is a very good thing, but I tend to only hear the horror stories. So my view of it can be a little bit coloured by that. Um, we know that in at least 17% of our cases, of our economic abuse cases that we deal with, there is a power of attorney issue involved, whether that's sort of dispute or concerns raised by one family member about another family member exercising power of attorney, and the way that they're doing that, whether it's concerns as to whether the power of attorney even exists. It is something that we do encounter frequently. So I mean, it comes up in at least 6% of our total cases every year. So it is, it's something that we are encountering quite a lot. And there are other issues as well around, mental capacity and someone's capacity to manage their kind of financial decisions, and how far and when somebody else should perhaps be supporting with that. So there's it is clearly a big issue.
Thanks, Colin. Now, Tanina, I think you recently published a report, did you? You're a learned author.
I wouldn't go that far, Ian. But yes,
on the prevalence of economic and financial abuse on our older and vulnerable adults. Can you talk us through what that report was focused on and what results you found and whether they were surprising to you?
not surprising to me. I mean, like Colin, I'm a little bit cynical because I do see the bad side of what's going on. But effectively, we put out a survey earlier in the year to raise questions really about how people are encountering financial abuse and economic abuse when it comes to older and vulnerable people. So it was open to public and private individuals, so professionals that work with older and vulnerable people, and really wanted to gauge whether everybody else's experience is like mine. Do we think it's underreported? Do we think it's happening a lot more than we're seeing and we're hearing? And that the results of that report have only recently been published, but effectively it reflected what I was expecting, which is that it is underreported. I think we had something like 70% of the individuals that completed that report had encountered economic or financial abuse of an older or vulnerable person in the last 12 months. And 28% of those individuals had seen it more than 10 times in that same time period. And I think for me, whenever I've met with the Office of the Public Guardian, they're saying, the misuse of powers of attorney in particular is only a small percentage, but it's still a very large number of people. So it's definitely more people than we would like to see. And we also saw that people's perception is that this abuse is on the increase. I think the cost of living crisis, there's a bit of a squeeze financially, a bit more temptation perhaps, higher care costs, which individuals always want to try to avoid. Inheritance tax issues as well, but people are just taking advantage and trying to move money around, thinking, mum won't need it, dad won't need it, and just dipping in. And it sort of snowballs when there's no checks and balances, which is why we do see those lasting powers of attorney that are supposed to be used to empower individuals and protect them. We're sort of seeing them used as instruments of chaos to actually perpetrate financial abuse. And that's what we saw reflected in the report also, is the experience was more digital use or methods used to perpetrate financial abuse, so making transfers and gifts to themselves, maximum cash withdrawals every day, and misuse of lasting powers of attorney was over 57% of people thought that that was the main sort of avenue that people were using to perpetrate abuse. So the purpose of that report really was to make a bit of noise, to raise a bit of data. I heard from the minister this morning that she was talking about data and how that sort of galvanizes the government to do something. And we just didn't have the data because it's so underreported and it's happening a lot more frequently than we see. So it's really our starting point to have a conversation and raise awareness. And next step really will be to get some key stakeholders together, Hourglass being one of them, to have a conversation about what we do next and how strategically we can try to make some of those changes and raise awareness so that we can have better safeguards and protections. At least that's the England and Wales side of things. And hopefully we see it follow suit in other jurisdictions as well.
Thank you very much. Well, we're going to come to some questions in a minute, but just really to bring things to a bit of a natural conclusion. Powers of attorney, and this is open to any of you to answer really and make a contribution to. Do you think there's firstly enough public awareness of them and their availability? Are they well known about? And secondly, are the dangers of them well known about? And what's your experience of the public awareness at the moment?
From my point of view, there is certainly an awareness of power of attorney. Everybody you speak to, I have a power of attorney, it's all fine. But I also think that a lot of people don't know that there are different types of power of attorney in Scotland. There's 3 different types of power of attorney. It's not a one fits all situation. I also think that they don't realise how quickly those powers can be enacted and how quickly somebody else has utter complete control over all of your finances, all of your medical decisions, depending on your situation. Effectively, you're telling the government you do not have capacity and this person is speaking for you. And I don't think people realise that. I don't think they see the pitfalls of power of attorney. They just see, well, this protects me. But there's so many pitfalls and not enough checks. People can't revoke power of attorney in Scotland in the same. There's no checks, there's balances, there's no ongoing support for people that have signed over their rights, or even for people who are doing the right thing and they want to document that everything's being done properly. I don't think there's the ongoing support for.
Yeah, I would agree. I think awareness of powers of attorney is certainly there as far as the public are concerned, and the Public Guardian does quite a lot in England and Wales to get that message out. But what is lesser known is really the responsibilities of attorneys. And for the amount of powers of attorney that I've done for clients in my career versus the amount of attorneys who have actually ever asked for advice about what they do, and their role and responsibility is shockingly different. So I think, yes, they're well known, but actually how best to use them and being independent and making sure that you're acting in the vulnerable person's best interests, that is where we're lacking. And also some of the professionals, as I say, the bank not applying a bit of common sense. Police have needed quite a lot of education as well about the powers that attorneys can exercise. And I think we just need some better awareness around that.
Colin, last word on awareness of
Yes.
advantages and disadvantages.
I mean, I would very much be in favour of more robust checks, routinely of attorneys. I think also, like from Spider-Man, that with great power comes great responsibility. And I think the power element of power of attorney is often kind of accentuated, with the responsibilities not quite being understood. Actually, there's a lack of understanding in my experience across not just donors not fully understanding and attorneys themselves then not understanding what they can and can't do, but also actually sometimes even professionals don't always fully understand. There's a huge deference I find at times to attorneys. So somebody turns up and says, "I have power of attorney," and everybody then kind of takes a step back and says, "Well, you know, thy will be done," which is just nonsense. You know, it is okay for professionals to question an attorney's decision.
Thanks, Colin. Yeah, it's certainly my experience that the number of situations that I get involved in where people have just taken it for granted that someone who says their attorney is an attorney. They haven't checked the professionals, the doctors, the nurses, banks. They haven't bothered to check whether that's the case and whether there are any limitations on the power of attorney. All of that is publicly available, and it's just not done. So huge awareness campaign is necessary there. Now we're going to come to questions, I think, so to try and involve our wider audience. I don't know whether Joseph is going to present these questions or whether I'm going to read them.
That's up to you, Ian. I mean, you can read them if you like, or I can
Okay.
post them. It's up to you.
Okay. Well, I'll address the couple that I can see here. I didn't know whether I had the whole list. So one of the questions here is, what do you think of this? When an attorney is removed due to safeguarding concerns, should there be an automatic referral to the police to investigate possible economic abuse? Anyone?
Absolutely. That's common sense, isn't it? It should be something that is done. I think there's a lot of teams in place, but they don't speak to each other, and things like economic abuse fall through the cracks because it's not seen as an issue. But actually, if they were reported, it would be an issue because they would see them. There would be the data there.
I think also from our experience, the solicitor in our case wasn't removed. We were told that, you know, he was very sorry and he understood what he did wrong, and you know, and that was it pretty much. He was asked to pay £5,000 to the Law Society. Nothing came to us or anything like that. So if it has got to the point that there is enough evidence that they can be removed, then they've done something very, very serious. So yeah, I would probably agree that there probably is a criminal case there, because to get them removed is very difficult, at least in Scotland.
Yeah, I would agree. I think that actually doesn't go far enough, because in my experience, when somebody is removed, there's no automatic consequence at all beyond that. And if they've been found to have mismanaged the assets, I think we should have an order that we can enforce on a civil basis to recover assets and restore assets to the estate, because that's a big problem. A lot of the time, there's no money left to actually pursue any legal action, and there is a public interest point here, because it's the local authorities footing the care bills then, and the taxpayers ultimately, where we don't recover assets for those estates.
Certainly in England and Wales, there is something called the presumption of undue influence, which is quite a useful component, because the claimant, the person bringing the allegation, normally has the burden of proving that someone has been dishonest, someone has done something wrong. But if you're in a position of trust and confidence, what we call as lawyers a fiduciary position, and money, you've ended up receiving funds of money from the fund that you're looking after for someone else, then there is a presumption that you have done so wrongly, and you have the burden of proving that you didn't, or that you had the fully informed consent of the donor for taking that money, which is a powerful weapon. But you've still got to argue this. You've still got to have a lawyer to do it effectively, and there is still a complicated process to go through. And there is the prospect, at least, of some evidence being produced on the other side which rebuts that presumption. So there is some help that the law provides where someone abuses a position of trust, but it's not a slam dunk outcome. Yeah. Okay. Let's see what other questions we've got here. Okay. Do the panel think there is enough training provided for potential attorneys or welfare guardians. In my role as an advocacy worker in Scotland, I've encountered several adult protection cases where abuse has been alleged, which is just due to a lack of knowledge about their powers. Would we all agree with that?
I agree there's not enough training. In fact, there's none at all for attorneys. There's guidance in England and Wales for attorneys that are acting, but again, in my experience, I see that when they are interviewed by police, when we do get it to that stage, they say, well, I thought I was allowed to do this. This is what mum would have wanted. And our key witness is incapacitated or has passed away in a lot of cases. So it makes it really difficult to pursue any criminal activity. But yeah, certainly training would be an advantage. And that's something I have discussed with the Public Guardian, but they simply don't have the resource or the inclination at this point to do it. It's not one of the metrics by which their success is measured. So we really need that to change first. We need them to have more of a duty for supervision and accountability as an organisation promoting these documents before we can sort of hold them to account for that. Because at the moment, it's just how many have you made and how quickly can you turn them around, and they're meeting those criteria. So we need better targets for the Public Guardian so that we can then have them do training, compulsory training for attorneys, I think.
I think during the Adults of Incapacity review, lack of training was a big issue that was brought up during that as well. And I would go further than say it's not just a training label or sticker. We don't want solicitors sitting down watching some video that they can skip forward and tick a button. We want proper training. Capacity is a huge issue, and whether it, I mean, I doubt that many solicitors would recognise signs of dementia, signs of medication incapacity, fluctuating capacities, brain injuries. I mean, really, solicitors, are they qualified to be making medical decisions like this, which should be a medical decision?
I think that's very true. I think I'm quite good at assessing capacity, but I think because of my association with Hourglass and because of the work that I do, I haven't had any formal training, but I do make full use of things like open questions because I'm very aware of the potential for undue influence to have occurred, for people to be under pressure to do something. And if they can't explain for themselves why they are taking a particular step, then you have to question whether they are taking that step in an informed way. Whereas the amount of social workers and other professionals who ask closed questions resulting in a yes or a no answer astonishes me, really. And there's no proper record often in a lot of assessments about what answers people have given, and those answers are then not drilled down in a way which it allows the vulnerable person to explain why they've done something. I mean, obviously the Mental Capacity Act allows people to make unwise choices, and if they've got capacity, they can make frivolous, silly choices that the society might condemn, and that's what the law provides, and that's probably right. But the more silly the choice, the more significant the step that you're taking, the more scrupulous scrutiny should be applied, I think, and that's just common sense. And a lot of people just want to shuffle through to the next job because they're overworked, under-resourced, and it's easier just to tick a box about capacity rather than actually turn any stones over and get to the real nub of the problem. Okay, it's 4:35. Joseph, are we all right for time?
I think we can probably fit in one more question since we did start a bit late. So let's just fit in one more and then we can wrap up there. If that's okay with everyone.
Yeah, of course. Right. Okay. Right. This is a big one to finish on. We've also, I think this is a subject in itself, but there's a question here about predatory marriage. and the fact that many legal complications can arise out of someone deciding to get married in later life, and the question about whether they have capacity to make that choice. The question here is obviously from someone who was an attorney, probably a child of a parent. Very few people seem to know that there's no connection between power of attorney and marriage. I had power of attorney for my mother, but there was no requirement or method by which I could be told that a man was planning to marry her. So no protection from this huge life event. In my view, she never knew she was married, and he inherited everything because marriage revokes a will in England. Should there be additional protection? Any comments on that huge subject? Because it does happen.
I think it'd be almost impossible really to have any automatic link between those two things. That's the difficulty. Predatory marriage is a huge topic, with the level of capacity to marry set deliberately low, but the capacity to divorce is higher, which is crazy. And even when we've got circumstances where there are vulnerable people who have got married and they've found that they didn't have capacity to marry, there's still been a marriage. So they still can, the perpetrator of that predatory marriage has still got potential to claim against the estate. There's certainly some work going on in the background to address this and look at that as a whole issue, but it's certainly again something that we see unfortunately quite a lot of.
I think the Law Commission are currently looking at, or have concluded, that marriage should not revoke a will, and it's apparently a Victorian principle which nobody can quite remember exactly why it was introduced as an important principle, but it's still there at the moment, and this is a continuing problem. So yeah, well, okay, thank you very, very much for all your contributions, and thank you for our delegates for their insightful questions. That effectively brings an end to this panel session. I'm really grateful for everybody's contribution, and Joseph, I think, can you remind us what's coming up next?
Well, this is the last panel session. This is now going towards the end of the conference. So
Well, we like
the
to end on
only
a
thing
high, don't we?
we do. The only thing that remains is for our esteemed CEO, Mr. Richard Robinson, to wrap everything up.